3, 2, 1, start. The charge under section 302 of the IPC was framed against the accused, namely, Purnendu Samanto, to which he pleaded not guilty, and as such the trial commenced, and almost 5 years thereafter the judgment was delivered on 18th April, 2008 in ST number 2/2006/SC number 204/05. And the learned court sentenced Purnendu Samanto to suffer rigorous imprisonment for life and to pay a fine of rupees 10,000 in default, to suffer rigorous imprisonment for 2 more years. Subsequent thereto, on 3rd December 2008, the petitioner made a representation to the respondent number 2 demanding compensation for the murder of her son, but the same was not responded to. Espousing the cause of the petitioner, a representation was also made by the president of the Association for Protection of Democratic Rights hereinafter referred to as the said association to the respondent number 2 on 3rd December 2008, but the said representations were not responded to, and accordingly the petitioner approached this court through the instant application under Article 226 of the Constitution of India on 11th May 2009. Records reveal that the writ application was admitted by an order dated 21st July 2009 with a direction towards exchange of affidavits. But in spite of such direction, no affidavit in opposition was filed by the respondents, and no extension of time to file such opposition was sought for. By an order dated 17th February 2015, the respondent number 2 was directed to file a substantive report as regards the steps taken by the respondents relating to the petitioner's claim, accompanied with the executive inquiry report as referred to in that document dated 3rd December 2008 at page 92 of the writ application, within a period of 4 weeks from the date of the communication of the order. Pursuant to such direction, a report was communicated to the petitioner by the respondent number 2, and the same along with the executive inquiry report was produced before this court on 24th April 2015. Mr. Raghunath Chakraborty, learned advocate appearing for the petitioner, submits that relief in exercise of power under Article 226 of the Constitution would be granted once it is established that there has been an infringement of fundamental rights of the citizens. In the instant case, it stands established from the judgment delivered in the sessions trial that the petitioner's son was brutally murdered by one Purnendu Samanto, a police constable attached to the Uttarpara police station. Oblivious of the constitutional guarantee provided under Article 21 of the Constitution, a police constable brutally murdered the petitioner's son, and for such admitted infringement of fundamental right, the state authorities are under an obligation to disburse compensation in favor of the petitioner. As regards determination of the quantum of compensation, reliance has been placed upon the averments made in paragraph 5 and to the documents in Annex P2 of the writ application. He further submits that section 357 of the Code of Criminal Procedure referred to as CRPC also provides for payment of compensation to the person who suffered loss caused by the offence, and that by way of amendment, section 357A was inserted proposing, inter alia, for preparation of a scheme for providing funds for the purpose of compensation to the victim or his dependents, who had suffered loss or injury, as a result of a crime, but no such relief was granted to the petitioner in the sessions trial, though even on its own motion the court could have granted such compensation irrespective of any application made to that effect. He further submits that in terms of the provisions of Protection of Human Rights Act, 1993 and international covenants, the petitioner is entitled to compensation for violation of the basic human rights. In support of such contention, he has drawn the attention of this court to section 2D of the Act, in which human rights are defined as the rights relating to life, liberty, equality and dignity of the individual, guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. Drawing the attention of this court to the impugned report filed by the respondent number 2 and the corrigendum as issued, Mr. Chakraborty submits that the said order is scriptive one, and the same do not reflect the independent application of mind, and in a most casual manner the petitioner's claim has been rejected without even considering the contents of the executive inquiry report, and accordingly the said order is not sustainable in law.